Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Rudel, and today I'm thrilled to welcome Ms.Edina Lim, Senior Associate at a leading Singaporean law firm. Ms. Lim's legal journey is impressive, graduating from NUS Law in 2019, whilst concurrently obtaining an LLM at King's College London as a part of a tie-up between NUS and King's College. She has carved out a specialization in intellectual property law, from prosecution to advisory work. Beyond IP, she also advises on litigation and gaming law, establishing herself as a dynamic and multi-talented lawyer. So, Ms. Lim, to start us off, how did you develop an interest and specialization in intellectual property law?
Hi, Rudel. Thanks for inviting me today. So, my interest in intellectual property law stemmed from an internship that I did. It was around my second year of law school. So, I did 1 month internship at an IP department in quite a big firm. And when I was there, I think I got to encounter quite a few cases, like on counterfeit products. And I attended a raid. And in doing all the work related to IP, I felt that the topics that I was encountering were of interest to me. I feel that IP generally is quite intuitive in that it has to do with things that you see in your everyday life. For example, your different brands, your inventions, things like books, movies, IP surrounds all of that. So it's something that is very tangible to even the layperson on the street. So I felt that it was an area of law that I could relate to, and that's how I got interested in it.
Thank you for sharing your journey and interest in IP law, especially how you got inspired from your internship and how various aspects of IP law can be seen in everyday life. That makes me wonder, for our listeners who aren't too familiar with IP, could you explain what it entails?
Okay, so the concept of intellectual property is that it protects a human's creative output. So whatever you think of in your head, that you put in your own originality and creativity into creating, and that is worthy of protection. So in terms of what exactly constitutes IP, there are a few main forms. So the first is patents, which protects inventions, and then there's copyright, which protects things like artistic works like paintings, or literary works like books, musical works like your songs, or even recordings. So, for example, like Taylor Swift buying back her master recordings. So, that's a form of copyright protection. And we also have other less common forms of IP like designs, trade secrets. So, that's the general broad categories. But the fundamental rationale for protecting intellectual property is to protect the spirit of human creativity and originality.
That's a really clear way of putting it, especially from stemming out from the fundamentals into many different branches. So this ties me right into my next question. How does working with creative clients differ from corporate clients?
So most of the time, the clients that come to us are actually corporate clients. But depending on the nature of the organization, then you may be working with the people who are responsible for the more creative side of the organization. So I think one key difference between purely corporate clients and people who are more on the creative side is that sometimes the creative clients have more of an emotional attachment to the work that they have created or the work that they want to protect. So quite a few of the maybe the legal provisions or the legal positions that we take, some of it that they request come from a more emotional perspective. I would say that's the biggest difference. And of course, in terms of explaining technical concepts, definitely it requires a bit more time to explain some of the fundamental IP concepts to lay clients compared to corporate clients.
It's interesting to see the various complexities of IP law and how creative clients differ from corporate ones, specifically in terms of their emotional attachment. Building on that, how does your approach for a contentious IP case differ compared to a non-contentious one?
So I would say that non-contentious IP work and contentious IP work is actually very different. So I do both. So for example, for non-contentious work, it would be things like drafting agreements, looking at the contracts between two parties that are actually working together to try and achieve a common goal. Whereas for contentious work, some dispute has already arisen and maybe our client is trying to take action against an infringer, or maybe our client is the infringer and is getting sued by another party. So it's really very different, because for non-contentious work, I would say that the focus is on being reasonable and achieving a win-win solution for all sides in terms of how you would draft the legal provisions and not insisting too much on protecting your own client's interests at the expense of the others, but rather how you can maybe choose a more nuanced provision that would be acceptable to both parties, so that eventually the collaboration can go ahead and is not blocked because of some legalities. Whereas for contentious proceedings, sometimes you will tend to start by trying to secure your own client's interests the most first. But of course, as with all contentious proceedings, there is always a chance of settlement. So when it goes towards where you see that maybe there's a chance for settlement and you start negotiating that, then it would become a little bit more close to what a non-contentious matter is, where both parties are trying to find a workable solution forward. Because litigation is always very expensive, so it may not necessarily be in the best interest of your client to pursue a contentious litigation proceeding right to the very end.
That's a great breakdown of how you handle different types of cases and how there might also be some similarity in both of them. On the client side, though, what's the most common issue you find that they underestimate when it comes to protecting their ideas or creations?
So I wouldn't say that there's a common thing that they all underestimate, but a very common issue that sometimes we see is that, let's say we have a startup that comes to us with a query and they have a brand in mind, and maybe because of cost concerns, then they decide not to proceed with like the trademark protection or other forms of IP protection. But the thing is, if you don't file for trademark protection early, someone else can come in and basically file for protection for the name that you originally wanted to protect. And because we are first to file system, if they file it first, then it's very, very difficult to try and defeat their registration once it's already completed because you didn't do a filing. So one common issue is that for smaller companies who don't really understand the importance of IP at the outset, and I mean rightly so, because they're more focused on other priorities like funding, they underestimate the importance of securing protection early, and also they tend to be daunted by some of the costs involved. So I would say that's one of the issues. Another thing is, for things like patents, patent registration can actually take quite a long time. So I think that is something that some clients, they don't expect that the patent process can actually maybe take around 2 to 4 years. And if you want to patent in more than one jurisdiction, it's going to take even longer. So that is also something that is a common surprise to some of the clients that we have.
This really highlights how protection can be tricky, especially for startups who want to manage a lot of other things as well, and for patent protection, which even I didn't know was this long. So with technology moving so quickly and, shifting focus to our changing world, how has the rise of AI, digital platforms, and just the globalization of the world shifted the IP landscape?
So I would say that in terms of patents, especially, we are seeing a lot more interest and a lot more queries into protecting inventions that have to do with some form of machine learning or generative artificial intelligence. But the problem is that when it comes to areas like generative artificial intelligence, the industry and the pace of technology development is just moving so fast that if you look at it in contrast with the time it takes to apply for and get a patent, it's basically going to render such protection a bit moot when you eventually get a granted patent protection. So I would say in terms of trends, we are seeing a lot more interest in protecting AI-related inventions. But at the same time, there's also the question of whether you really want to use that form of IP protection, meaning patent protection, to protect your AI invention because of the speed at which the industry is going to change. Because if it takes 2 to 4 years for you to get a granted patent, by the end of the 4 years, when you finally get your patent, you may not need to use your invention anymore because it probably is superseded by some form of technology. So I would say that's the trend we are seeing. And of course, there are different considerations that you have when you're trying to file for IP protection. So sometimes we would recommend clients that if the thing that you came up with, that you invented, if it's not easily reverse engineered, if you release it to the public, then maybe you don't need to apply for patent protection. You can protect it as a form of trade secret, meaning that if your employees work on it, you get all of them to sign non-disclosure agreements and you protect it contractually rather than applying for a form of IP protection, because that may be the best way to protect something that needs protection urgently rather than going through the patent protection route.
Yeah, it's fascinating on how the speed of digitalization affects the application for a patent, and more so how the rise of AI protections has been affected due to the rapid changes in the industry. On a related note, with regards to your work in gaming and litigation, how do you see those areas intersect?
Okay, so in terms of the intersection between IP and gaming and litigation, so for example, IP, there's non-contentious and contentious matters, like I mentioned. So IP litigation would be when you go to court because of some infringement lawsuit, or you could refer to maybe trademark proceedings where you file a trademark and it's published and somebody opposes your trademark registration, maybe on the grounds that they already have a similar mark. So that's generally the IP disputes portion. For gaming and IP, because my department is also called the gaming department, IP, sports and gaming. For gaming IP, there is actually a lot of overlap because in a game, you have the computer software, you have the graphics. Our team has represented a few clients in the gaming space in respect of intellectual property infringement cases. Then there is a very interesting question of whether, because it's not like a static picture where, let's say you take a photograph, somebody copies your photograph, or you draw a picture and somebody copies your picture. It's a static picture. But when it comes to video game, then the user controls the character in the game, and depending on what the character in the game does, then whatever appears on your screen is also different. So the question is whether each different frame of the game, can that constitute a form of copyrightable artistic work that is then infringed by somebody else that copies maybe certain elements of the game. And even when you look at elements of the game, it's a bit difficult to say that, oh, because this character in game A is very similar to another character in game B, does that necessarily mean there's copyright infringement? So those are the interesting issues when it comes to video games and IP protection.
That's a really insightful perspective on the intersection between gaming and IP law, as well as how it can be tricky to define if there has been a copyright infringement. Could you elaborate more on some key legal challenges in the gaming and IP industry?
Yeah, so I think when you look at the basic IP principles and you try to apply it to new technology, not just video games, but even AI and things like that, when you apply it to emerging technologies, then some of the fundamental principles of IP law are a bit more difficult to apply. So, for example, even the fundamental question of what constitutes a copyright work, that may be something of dispute because somebody may argue that each frame of the game, when there's a different scene, that's one artistic work. And that would mean that if the elements are similar, then there could be multiple works that are infringed. So even for new technologies, not just gaming, video games, but like AI. I mean, we all know of the open AI software that allows the Ghibli style to be essentially replicated by anybody who uses the generative AI. But the fundamental principle of intellectual property is that they protect the expression of someone's creativity, but not a certain idea. So when it comes to a style, where it's very clear that this style is Studio Ghibli style, but copyright can't really protect a style because a style is not really any form of copyrightable work. But everybody clearly knows that it's Studio Ghibli's style. Yeah, that's where the fundamental IP principles don't apply so neatly. And that's also the interesting part of applying IP to new emerging technologies.
Your experience really highlights some of the pressing challenges in this field and how IP principles can't always cover the idea or style, with your notable example of the Studio Ghibli art style being used in AI. Finally, for young lawyers hoping to build a practice in these areas, it could be IP or any of your other areas you practice, what guidance would you give them?
So, personally, for myself, I still feel like I'm a young lawyer trying to build a practice in this area. I would say that probably one of the more important things would be to keep updated with how technology is developing and to see what kind of areas IP can become relevant to in terms of the different industries, even in terms of offering legal protection for these types of new emerging technologies. Because fundamentally, I think a lot of things are going to change and the rapid speed of development of generative AI. So in order to catch that wave, I think it's very important to keep updated with what the latest development and see how our current knowledge and how IP law in general can actually serve the purposes of the people who are creating all of these new things in these new industries.
That is extremely valuable advice and very well broken down for aspiring lawyers to keep up with the news and technology. Well, once again, thank you so much for your time and insights, Ms. Lim. And to all my listeners, court is now adjourned until next time with the fine print.